Rob Lambert's AssetProtectionTraining.com presents Ryan Fowler on Tenants by the Entirety and Co-Ownership.
Hi, my name is Ryan Fowler and welcome to the AssetProtectionTraining.com video series. This is part 4 of a series we're doing about different asset protection strategies for protecting your home. So today we're going to talk about tenants by the entirety and other types of co-ownership. So let's go ahead and get started. So there are basically, when it comes to owning real estate such as a home, there's basically 4 types of co-ownership. We're going to talk a little bit about each of them. These types of ownerships that I'm listing here generally apply only to real estate, although there are a few exceptions. There's tenancy in common, joint tenants with right of survivorship, tenancy by the entirety, and then community property. Only tenancy by the entirety offers meaningful asset protection. The other forms of ownership actually have some pitfalls to them that we need to make you aware of. So if you own an asset in these other ways, you know what those pitfalls are. Not all states allow for TBE ownership. We're going to list the states that do and give you a rough idea, really kind of a general idea to what extent a particular state allows TBE ownership. But let's examine these 4 types. So tenancy in common is a very common way to own real estate. It's very flexible. Each owner, whether it's 5 or 20 or 2, they can sell their portion without consulting or needing the permission of the other tenants in common owners. It doesn't have to be equal ownership. As you see in the example there, one owns 30% of the property, the other owns 5%, the other owns 25%. Each person, like I said, they can sell it at their will. Creditor of any person who has a tenants in common interest can foreclose on the entire property, but what happens is, let's say there's 3 people and they each own 1/3 of the property as tenants in common, and one of them gets sued or gets a judgment against them. Well, they can foreclose on that property and then they get 1/3 of the proceeds because that tenants in common person have 1/3 interest in the property. But still, the other guys, they'll get compensated. They'll get 1/3 of the foreclosure proceeds, each. The other owners that were not debtors, they still lose the property. So that's a pitfall you need to watch out when it comes to tenants in common ownership. If you have 20 owners, you only need one of the tenants in common owners. Even if he owns 1% of the property, someone could theoretically foreclose and they only get 1% of the proceeds, but you lost the property foreclosure. So joint tenants with right of survivorship, or JTWROS. That's how us gangsters call it, slang. Okay, so each person, joint tenants with right of survivorship, several criteria you have to meet. And here they are. Everyone requires the property at the same time. Everyone has an equal share of the property. If there's 4 owners, they each own 1/4. They have the same type of title, and they each have complete access to and benefit and enjoyment of the property in its entirety. Let's say you have 4 owners that own a property as JTWROS. When one of them dies, there's 3 owners left. Now each of the 3 owners have 1/3 interest. If another person dies, now there's 2 owners and they each have 1/2 until there's only one person left. Now with tenants in common, if someone has a tenants in common interest and they die, their interest passes to the heirs, not to the other joint owners. So that's the difference between those 2. Tenants by the entirety. TBE ownership is only allowed between husband and wife, and only a creditor of both the husband and the wife can grab TBE property. If a creditor is a creditor of the wife but not the husband, or in most instances, creditor of the husband but not the wife, they can't get the property. They can't get any of it. So you get some creditor protection there. Now, an aggressive creditor, he might try and find a way to make both people a co-defendant on a lawsuit, both the husband and the wife, or say that they're both a debtor, or he might try and find another way around the protection that tenancy by the entirety offers, but he may or may not be able to do that. Now, if one spouse dies, then 100% of ownership automatically passes to the other spouse, and it ceases to be considered TBE property. So you lose the creditor protection, but it does avoid probate. It just goes to the other spouse. No probate in the deceased spouse's estate. If you're divorced, and you split the property in half, where it all goes to one person or the other, then it just becomes tenants in common ownership or single ownership. No more TBE. If one spouse owes the IRS gets an exception. They get half the property, regardless. So that TBE protection doesn't really apply. They'll get the half of whichever spouse. The husband owes the IRS back taxes, they'll grab the husband's half. They can put a tax lien on it or even foreclose on it and get half. So be aware of that. Now, also, just as an aside, if a husband and wife file joint tax returns, then the IRS can go after either spouse for the tax debt of whichever spouse. So if the husband doesn't pay his taxes, they can go after the wife for 100%, meaning they're going to get the entire TBE property if you file joint tax returns, at least for the tax years that you filed that are delinquent that you filed jointly. So TBE, a lot of loopholes. We're going to talk about the loopholes in a second. Definitely should not be your only line of defense for an asset protection standpoint, but it's easy to do. It's easy to file a quit claim deed or some other type of deed transferring your ownership from just in one spouse's name or as a tenant's common interest to a TBE interest. So why not do it as long as you have other lines of defense? Why not get this extra line of defense that very well may work, although not guaranteed to, if it's really hassle-free and inexpensive to do it. So let's talk about TBE for personal property. There's actually some states that allow TBE to only own real estate. A few states only allow tenancy by the entirety for ownership of a home. That's it. Other states allow tenancy by the entirety ownership of real estate, but not personal property. And then others, they at least leave this, maybe specifically not authorize this, but leave the statute open to own other property types besides real estate as tenancy by the entirety. And here's a list. I'm not going to read every one, but here's a list of states that allow TBE ownership, possibly for personal property in addition to real estate. And then moving on, this is allowed for real estate only, and a couple of these is only for your home, and that's it. And then these states do not allow TBE ownership, and so if you live in any of these states, you're just not going to get the protection of tenancy by the entirety ownership. And then there's a few states where it's really unclear whether or not TBE ownership, tenancy by the entirety, can be used. And so there's a list of those there. So let's talk about TBE ownership of personal property. It's very much a gray area. Some states it doesn't forbid it, but it might allow it. A lot of these statutes are kind of vague. One exception where there's some case law that has actually upheld TBE ownership of certain types of personal property when that was challenged by creditors is Florida. In Florida, you can own an interest in an LLC or a bank account or a trading account. There's a lot of different types of property. I'm not going to say all types, but a lot of different types of property. Husband and wife can own as TBE. You can have a tenancy by the entirety bank account. And if you have that in Florida, where they let you do that and recognize that if someone sues you, only sues one spouse, they can't get that bank account. So if you live in Florida, that's a great idea. Don't have a regular joint account. Go to a bank and try and get a TBE, tenancy by the entirety bank account. Some banks in Florida do it, some don't. I've had clients try to go to other states and try and get a tenancy by the entirety bank account. Haven't had success. It seems like Florida is a little... if there is another state that allows a tenancy by the entirety bank account, send me an email to my AssetProtectionTraining.com email account. I would love to know about that. Florida is the only one I've seen. But also you can own partnership interest as TBE. You can own your LLC interest as tenancy by the entirety. What that means is normally someone can get a what's called a charging order against your LLC or limited partnership or interest. And they can't even get a charging order. Charging order means if and when money comes out that's going to you from the LLC or partnership, the creditor will get that money or assets instead of you. Well, if you own that interest as TBE and they can't get around the TBE, then they can't even get the charging order. So why not put that in an operating agreement if you're able to do it? And it might be worth a try in other states besides Florida. Why not give it a shot? If it fails, we're not relying on TBE by itself, but it's an extra layer of protection. If that fails, we have other layers of protection behind it. So it could be a good idea. And so just a reminder, never rely on TBE by itself. Here's a court case where TBE property ownership failed. In Massachusetts, this was a real shock, I'm sure, for the people who own this property as tenants by the entirety. What Massachusetts decided was that their tenants by the entirety law only applied, is only effective against creditors of the wife. And what they said is, well, our tenancy by the entirety law was formed so that the wife could not alienate the property without the husband's permission. This was way back in the 1800s, before the women's suffrage, movement and the feminist movement came along, before there's all the women's rights movement. And so they said, well, when the law came out, it said the husband can alienate this property anytime he wants if it's tenancy by the entirety, because he's a dominant one. That's what the law said. But we want to make sure that the wife doesn't screw up things for the husband, so there's a double standard here. And the law was never rewritten, and so that's how the court ruled. And there are a fair amount of states that, although the court hasn't decided along these lines, their tenancy by the entirety statute is 150 years old or 100 years old, and a state, I'm not saying a state will rule this way in other, I'm not saying a court will rule this way in other states, but they could, because a lot of these laws are archaic, and there's actually only 3 states that have updated their laws so that it specifically goes both ways, so it's protected against creditors of the husband or creditors of the spouse individually. And so it's murky. TBE protection, it's murky. Very well may work, not guaranteed to work. There's a court case there to show you what I mean. And so word to the wise. And I believe that's the last slide. Oh, community property. Let me talk about, we have a few more slides. Community property, these are the states where if you're husband and wife, any property you acquire during your marriage is automatically deemed community property. These are the states here where community property laws exist. Other states, you don't have to worry about it. So it's deemed owned 50-50 between spouses. Property acquired before the marriage should be considered your sole and separate property. It's community property. Community property is not protected like tenancy by the entirety is. A creditor of either spouse can attach 50%. That spouse is 50%. You can do what's called a transmutation agreement, and that will override the normal community property statute, and it will make property you designate in this agreement your specific property and not property of your spouse. And of course, your spouse will have to sign the agreement and agree to that. It may be a good idea in a community property state to have certain property set aside as your separate property if you are a spouse with low risk of liability, but your spouse, the other spouse, high risk of liability, practicing physician or real estate developer, high risk profession. Put all the assets in the low risk spouse's name and have a transmutation agreement so it shows that that's how it is. That could be, again, not a perfect asset protection line of defense, but it could be helpful. Just watch out, because if you put all the property in one spouse's name and then you get divorced, I'm not saying that that spouse will keep everything, but they very well might. It could get really messy. So you have to be careful with that. That's a downside to that. And that is the last slide. That concludes our discussion on co-ownerships. I hope you find this information useful. Thanks.